Hi, welcome back to my channel. Jodie Hill here from Thrive Law, and today it's whistleblowing. Whistleblowing, what is it? Well, whistleblowing is where an individual reports some kind of wrongdoing. So usually it's going to be something like reporting a criminal offence, a breach of a legal obligation, a breach of health and safety. There's a number of different areas, and there's a blog on our website which I'll pop a link in the description for more information. But essentially what you need to do is provide information to the prescribed person. So check whether your employer have a whistleblowing policy of to who you're supposed to whistleblow to. I would always make sure whistleblowing is done in writing, because often what we find is that employers will say, one, it didn't happen. Two, if it did happen, it doesn't amount to whistleblowing because it didn't provide enough information. Whereas if you've got that in writing, you can obviously refer back to that as evidence that you actually whistleblew. The other thing that you need to consider is that you're doing it in good faith. You shouldn't be whistleblowing out of malice or to get back at an organisation. You should genuinely be doing it in good faith and in the public interest. So an example of that might be if your health and safety is breached but nobody else's is, it's unlikely to be whistleblowing. But if you work, say, in the NHS and you whistleblow about the safety of the hospital, then it's in the public interest. So you do have to make sure that it's not just about you and your contract, but in fact there's that wider public interest. So a recent example that is coming up all the time is furlough fraud. Furlough fraud is a criminal offence. So if an employee gives information to an employer about this, about any kind of furlough fraud or any fraud for that matter, but for this example, furlough fraud, and they say, you're doing this, it's wrong, I don't want to do it, and they put a complaint in, or they raise it as an allegation, doesn't even have to be a complaint, provided that there's enough information given, they do it in good faith, and it's in the public interest, which clearly it is, then they are protected as a whistleblower. But what does that mean? So when you're protected as a whistleblower, what that means is that you are able to claim if you then suffer a detriment. So a detriment could be something like being dismissed, being demoted, being docked any pay, being treated in any other way that could amount to a detriment. So kind of less favourable treatment almost. But really, often what happens is what we're finding at the moment as well is people are whistleblowing and then the employer want them out of the business because they don't want that out in the public domain. So if that does happen, you may have a claim for whistleblowing. Now, we do have a free helpline, so you can send that information to us. But like I say, whistleblowing is not the easiest claim to bring. There's quite a lot of legal steps that you need to go through. So if you're genuinely concerned, take advice before you whistleblow, and take advice before you leave if you then want to leave employment. Obviously, if you've been dismissed, come to us, tell us what's happened, and we can conduct a free initial assessment on our free helpline. Hopefully this has been helpful. I'm going to do another video for employers on whistleblowing shortly, but this is really focused on what employees should do if they find themselves in this situation. We've got loads of information on this on our website, so please go on the website and have a look at all of the blogs that we've got around whistleblowing, redundancy, furlough, you name it, it's on there. Thank you so much for watching, and I'll see you soon.